Hello everyone, welcome to today's class. Today we are going to study Civil Procedure Code, that is CPC 1908 and the law of limitation. So this is a paper 1 for the semester 5 of LLB 3 years. So we'll cover here in 5 parts: basic concepts, court procedure, execution of decrees, appeals and limitation of law. By the end of this class, you should be able to explain how a civil case moves from starts to finish and know the important timeline under this limitation law. Let us go to the next slide. What is CPC? So CPC understands for Code of Civil Procedure 1908. In simple words, it is a rule book that tells courts how to handle civil cases, that is property disputes, money disputes, contracts, etc. It does not give new rights, it only tells how to go to court and get those rights enforced. So, why do we know the CPC? So why do we need it? Because in every court in the country follows the same fair process. It has 158 sections. These are the main rules and don't change often. It has 51 orders. That means with the rules under them. These explain step by step how to do in part. Okay, so it's easy to remember. Sections are skeleton, that is the main rules. Orders are the flesh, that is the detail steps. Let us go to the next slide. Suits and parties. A suit simply means a civil case. It starts when someone files a plaint, that is a written complaint in court. There are two kinds of parties in a case. One is necessary party, another one is proper party. So necessary party, a person who must be there in the case, or the court cannot give a full and fair decision. And proper party, a person who is good to have in the case, but the case can still be decided without them. So bars to suit means reason why a case cannot be filed or cannot be succeed. So let us see one of the concept. Res Judicata means matter already decided before. Limitation means too much time has passed. No jurisdiction, that means wrong court. Any other rule made by a specific law that stops the case. Let us go to the next slide. Jurisdiction and place of suing. So jurisdiction, which court to go to. So before filing a case, the first question is, which court should I go to? So this is called as jurisdiction. So these are divided into three types: territorial jurisdiction, that means based on where the defendant lives and or where the issue happened, whereas pecuniary jurisdiction means based on how much money the case is worth. And third one, subject matter jurisdiction. The court must have the legal power to hear that type of case. So, under section 24, the High Court can transfer a case from one court to another if needed for justice. So, important information here: if a court has no jurisdiction and still gives a judgment, that judgment is completely invalid, or simply we can say that null and void. Let us go to the next slide. Res Sub Judice versus Res Judicata. So these are the two sounds similar but different things. A common exam question here. Section 10, Res Sub Judice. This applies when the same case is still going on, that means pending, in another court where the same people, between the same people. So res sub judice means this applies when the same case is still going on, that is pending, in another court between the same people. So the new court will pass. Pass means stay. The second case is, so both are not the heard in the same time. So that is called as section 10 res sub judice. We'll go to the section 11, that is res judicata. That means this applies when a case is already have been fully decided. The same issue between the same people cannot be brought to court again. So simple line you have to remember: res sub judice means case still pending. Res judicata means case already decided. If you want to have this screenshot, you can take. Let us go to the next slide. Summons and service. Once a case is filed, the court must inform the other side, that is the defendant. The notice is called summons. Steps here: court issues summons, then summons is served, that is delivered to defendant, then defendant confirm the receipt, then proof of delivery is given back to the court. So three ways to deliver summon. Summon means this is a here like notice. So personal service, that means handed directly to the defendant, whereas substituted services used when the person cannot be found directly, so it is put up at their house, that is called as substituted services. Then service by publication, there is a printed newspaper when the person cannot be traced at all. So summons sent outside India are covered under 5. Okay, this is a thing. The notice is called as summons. So summons, how many types? Personal services, substitute services, service by publication. So there are 3 ways to deliver the notice, that is summons, as I mentioned. Let us see about the next slide, that is pleadings. What is pleading? Pleading means the plaint, that is a plaintiff's complaint, and the written statement defendant reply. So together they tell the court exactly what is the dispute about. Okay, pleading should start only facts, not law, not evidence. They should be a short and clear. No party should be surprised during trial. Everyone should know the case in advance. So, pleading can be changed later, that is called as amended under 6 rule number 17. If a pleading is useless or troublesome, it can be removed. So that is struck out under order 6 rule number 16. Let us go to the next slide. Plaint, what it must have and when it's sent back or rejected. Order 7 says a plaint must have name of the court, names of both the parties, the facts, and the plaintiff's wants, that is a relief, and value of the case, and a signature. So, return of plaint, rule 10, happen when the court has no jurisdiction. The plaintiff can take the same plaint and file it in the correct court. So this is not a final decision. Then rejection of plaint, there is a rule 11, happens when there is a problem in the plaint itself, like no valid claim shown, claim is time barred, wrong value given, or not enough court fees, that is not enough court fees paid. So this is a final decision and it can be appealed. Remember, return means wrong court, that is a jurisdiction problem. Rejection is a problem in the plaints itself, that is a legal defect. We'll see about the written statement, set off, and counterclaim. So, order 8, the defendant's reply to the plaint is called written statement. So, every court in the plaint must be clearly denied. If not denied properly, it is treated as accepted. It must be filed within 30 days and the court can extend this up to 90 days. So, set off rule 6. So, the defendant says, you, that is a plaintiff, owe me a fixed amount of money to. It must be about the same transaction. This is a defense move. Counterclaim. So, the defendant makes their own separate claim against the plaintiff. It can be about anything, not just the same matter. So, this is more like attack, not just defense. So, here one thing you have to remember, set off, that is a fixed amount, same transaction, defense. Whereas counterclaim, that means any claim, any transaction, like a new case. We'll move to the next slide. Documents, section 89, that is a settlement and the framing of issues. Documents that a party wants to use must be shown in the first hearing that is a order 13. If not shown, then they may not be allowed later. So section 89 allows the court to send the same settlement through arbitration, conciliation, mediation, or just lok adalat. So instead of full trial, this helps reduce court workload and helps the parties settle peacefully. Framing of issues, there is a order 14, means that the courts decide exactly what points are in dispute. Issues of two kinds: issues of fact, issues of law. So we'll see in the next slide: appearance, examination, adjournment. So order 9, parties must come to court in the fixed date fixed. If the defendant does not shown up, the court may decide the case without them ex parte. Then order 10, the court can directly ask the parties question at the first hearing to understand the real dispute. So order 17, so the court can allow adjournment, that is postponement, only for good reason, and normally a party gets maximum 3 adjournments. So the court can also charge a cost for causing delay. We'll go to the next slide, that is witness, evidence and affidavits. So witness also are called to give evidence under order 16. Their statement go through 3 stages. One is examination in chief, that's the questions by the side that called witness. Cross examination, questions by the other side to test the witness. Re-examination, the first side asks follow-up questions to clear up anything raised in cross examination. So documents used as evidence are marked as exhibits under section 104. A document may be kept back, that is impounded by the court. For example, if the correct stamp duty was not paid, affidavits, that is a written sworn statement, can also use a evidence under 19. So we'll go to the next slide. Judgment, decree and order. So this is another favorite comparison question. Judgment, section 2 9, the reasons given the judge for the final decision. Degree, section 2 of subsection 2, the formal final decision that the settled rights of the parties. Order, any formal decision of the court that is not a decree. Okay, remember, a decree can always be appealed. An order may or may not appealable. So it depends on the rule. So interim orders, that is called as temporary orders given while the case still going on. So temporary injunction order, okay, that is so which stops the party from doing something. So stay of suit, that is a section 10. So pausing the case, already explained above. Attachment before judgment, so the courts hold the defendant's property early so they can't sell it off to avoid paying later. Then we'll go to the next slide, receiver, commission and cost. Receiver. So a person appointed by the court to look after disputed property while the case is going on. Commission. So order. So someone appointed to examine witness, inspect property or investigate something the court itself cannot easily to go and check. Then cost section 35, the court decides who pays the expenses of the case. Usually losing side pay the cost. We'll go to the next slide. Execution of decree, how a winning party actually gets their result. Winning the case is not the end. The winner must also make sure that the order is actually carried out. The process is called execution. So the steps here: file execution application. The court sends notice to the person who has to pay or do something judgment debtor. The court decides the method. The decree is satisfied. That is a completed. So three main ways to execute a decree: arrest the detention, that is a order 21. So the person may be arrested and kept in civil prison. Usually it is a last option for money cases. Attachment and sale. So the person property is taken and sold to recover the money. Whereas delivery of property, so in the case was about specific property, that property movable or immovable is handed over to the winning party. We'll go to the next slide. So here special types of suits. So suits against the government, that is a section 80. You must give 20 months notice before suing the government. Minor. So minors cannot sue on their own. They sue through next friend, an adult representing them and or defended by a guardian ad litem. So poor person, that is the indigent person. So this order says, can you file case without paying court fees if they prove they cannot afford it? Okay, this is in order 33. Okay, then interpleader suit, that is order 35, used when two people are fighting over the same property, which is a third person who has no interest in it. So the third person asks the court to decide who is really owner is. Okay, this is the thing. We'll go to the next slide. Appeals, reference, review, revision. So another very important comparison table for the examination. First appeal, that is a section 96, filed by the party who is unhappy with the decision on both the facts and law, goes to highest court. The second appeal, section 100, only allow there is a major substantial question of law, not just fact, goes to the high court. So reference section 13, 113, a court itself asks the high court for guidance when it is not sure about the point of law. Then review section, it is 114, asking the same court to look its own decision again, usually because of new evidence or the obvious mistake. Then revision, there is a section 115, the high court checks if a lower court made a mistake about the jurisdiction. There is a power to decide. So simply memory line you have to remember. Appeal, that is a high court. Reference means court asking for help. Review means same court correcting itself. Revision, high court supervising lower court. Okay, this is a simple one. Try to take the screenshot and so that you can attempt very easily. Then law of limitations. Let us discuss the basics. Now we move to the Limitation Act 1963. So why does the law exist? So why it is existed the law? To stop very old stale claims and to bring certainty to legal matters. The famous line is, law helps the vigilant, alert person, not the indolent person. That is a lazy person. Meaning, court help the people who acts on time, not people who wait too long. In simple words, limitation is a time limit within which you must go to the court and or you lose your right to sue even if your claim is genuinely correct. So the exact time limit is different for different types of cases given in the schedule of the act. So section 12 says, while counting the days, the day on which problem first happened, there is a cause of action is not counted. So this time the time limit can be increased in special situation like fraud, mistake, or if the person is under some legal disability. So we'll explain in the next. So we'll go to the next slide. Condonation of delay, acknowledgement, part payment and legal disability. Condonation of delay, that is section 5. If a person is late in filing something but has a genuine good reason, the court may forgive the delay and still allow the case. But remember, this rule is only appeals and applications, not for a regular suits. Acknowledgement, that is a section 18. If someone admits in writing that they owe money before time limits end, the limitation period starts fresh from that date. So part payment, section 19. If a person pays a part of the debt before the time limit ends, so the limitation period again starts from fresh and from the date of that payment. Then legal disability, section 6. If a person is minor or unsound mind or an idiot, when their right to sue starts, the time limits only begin once the disability ends. For example, once a minor become adult. Let us go to the next slide. It is just like revision. Res Sub Judice versus Res Judicata. Pending cases versus already decided case. Return versus rejection of plaint. Wrong court versus problem with the plaint itself. Set off versus counterclaim. So that is a fixed amount, same matter versus any claim, any matter. Judgment versus decree versus order. So judgment means reasons given versus final formal revision decision versus any other formal decision. Appeal versus review versus revision. High court versus the same court versus high court supervision. So some of the like important question, go through this one. So end of this particular class, so CPC and limitation, please read through the 10 questions, like explain res judicata and essential, distinguish between written and rejection of plaintiff, what is set off, distinguish from counterclaim, explain modes of execution of degree, what a note, write a note on section 18 and CPC, explain condonation of delay, distinguish between appeal, review and revision, what is res sub judice, that is section 10, explain acknowledgement under limitation act, what are the essential valid plaint. Okay, so before the next classes, and try to write full answers and make between differences, and so any question you have, you can ask in the comment box. Okay, so thank you for watching. We'll meet in the next class. Thank you. All the best for your coming examination.